this is ridiculous. Move your cart.
Ma'am, I'm conducting an inspection. Let's just talk this out.
No, this is...
I was walking my service dog, Max, down our street when Karen rolled up in her golf cart and stopped right in front of me. "That dog has to go," she said coldly. "You have 48 hours to remove it from this community." I looked at her in disbelief. Max is my service dog. I have PTSD from my time in the military. He's protected by law. She waved it off. "I don't care what you call him. The HOA has a no pets rule. Section 8.2. No dogs over 25 pounds. I said, "Service dogs aren't pets. They're protected under the Americans with Disabilities Act and the Fair Housing Act. You can't ban them." Karen gave a smug smile. "This is private property under HOA authority. Your emotional support animal doesn't override our bylaws. Remove the dog or pay a $500 fine every day." I answered, "He's not an emotional support animal. He's a trained service dog. There's a legal difference." She snapped back, "Then show me certification." I told her, "The ADA doesn't require certification, and you're not allowed to demand it." She crossed her arms. "I am demanding it. No paperwork, no dog. You've got 48 hours. Then she drove off. I went home trembling, not from rage but from a panic attack. Max leaned into my leg, doing exactly what he was trained to do. He'd been with me for 3 years, helping me through PTSD episodes, night terrors, and sudden anxiety. The next morning, a violation notice was taped to my door. Unauthorized animal on the premises. Fine of $500 per day starting in 48 hours. Failure to comply would lead to legal action and possible foreclosure. I called a disability rights lawyer right away. "They can't do this," she said. He said after reviewing the notice, this was a direct violation of federal law. Service dogs are clearly protected. An HOA cannot ban them, cannot charge extra fees for them, and certainly cannot threaten foreclosure because of them. I asked what we should do next. He said we would start by sending a formal letter explaining the law. If they refused to comply, we would file a lawsuit for discrimination, emotional distress, and civil rights violations. The attorney sent a detailed letter referencing the ADA, the Fair Housing Act, and multiple court cases. It stated that service dogs are not pets, cannot be prohibited, and that threatening a person with a disability over their service animal is illegal discrimination. Karen's reply arrived 2 days later. She wrote that they had spoken with their lawyer and were standing by their decision. Remove the dog or face penalties. They chose to double down. My attorney read their response and gave a tight smile. He said they had just made things far worse for themselves. We filed a lawsuit and pursued the maximum damages. The claim was for $300,000, citing discrimination, disability rights violations, emotional distress, and federal civil rights abuse. Karen had no idea what she had triggered. The lawsuit shook the HOA to its core. Within a week, their lawyer contacted mine trying to negotiate. They offered to cancel the fine.
He's very protective.
I can see that. He's a good boy.
Yes, the best.
Fines and allow the dog. My attorney said that was not enough. He told them their client violated federal disability laws, threatened foreclosure over a service animal, and caused serious emotional harm, and that we were going to trial. Karen rushed into an emergency board meeting to complain about what she called a ridiculous lawsuit. I attended with my lawyer and Max. "This is insane," Karen shouted. "He is using his disability to ignore HOA rules. That dog is just a pet." My attorney replied calmly that the dog was a trained service animal for a combat veteran with
ridiculous. Move
PTSD.
your cart.
He said
Ma'am,
their
I'm conducting
refusal
an
to
inspection.
accept that
Let's
fact
just
was
talk this
exactly
out.
why they
No,
were
this
being
is
sued for
harassment.
hundreds of thousands of dollars. Karen argued that they had the right to enforce their bylaws. My attorney answered that they did not when those bylaws violated federal law.